Be ready. Start. Section 3(1) of the 2009 Act provides that every child of the age of 6 to 14 years shall have a right to free and compulsory education in a neighborhood school till completion of elementary education. Section 3(2) inter alia provides that no child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing the elementary education. An educational institution is charitable. Advancement of education is a recognized head of charity. Section 3(2) has been enacted with the object of removing financial barrier which prevents a child from accessing education. The other purpose of enacting Section 3(2) is to prevent educational institutions charging capitation fees, resulting in creation of a financial barrier which prevents a child from accessing or exercising its right to education, which is not provided for vide Article 21A. Thus, subsection 2 provides that no child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing or completing the elementary education. Section 4 inter alia provides for special provision for children not admitted to or who have not completed elementary education. Section 5 deals with the situation where there is no provision for completion of elementary education. Then, in such an event, a child shall have a right to seek transfer to any other school, excluding the school specified in subclauses 3 and 4 of clause N of section 2 for completing his or her elementary education. Chapter 3 provides for duties of appropriate government, local authority and parents. Section 6 imposes an obligation on the appropriate government and local authority to establish a school within such areas or limits of neighborhood as may be prescribed where it is not so established within 3 years from the commencement of the 2009 Act. The emphasis is on providing neighborhood school facility to the children at the Gram Panchayat level. Chapter 4 of the 2009 Act deals with responsibilities of schools and teachers. Section 12 1C read with Section 2 N 3 and 4 mandates that every recognized school imparting elementary education, even if it is an unaided school not receiving any kind of aid or grant to meet its expenses from the appropriate government or the local authority, is obliged to admit in class 1 to the extent of at least 25% of the strength of that class children belonging to weaker section and disadvantaged group in the neighborhood and provide free and compulsory elementary education till its completion. As per the proviso, if the school is imparting preschool education, the same regime would apply. By virtue of section 12(2), the unaided school which has not received any land, building, equipment or other facilities either free of cost or at concessional rate would be entitled for reimbursement of the expenditure incurred by it to the extent of per child expenditure incurred by the state or the actual amount charged from the child, whichever is less, in such manner as may be prescribed. Such reimbursement shall not exceed per child expenditure incurred by a school established, owned or controlled by the appropriate government or a local authority. Section 13 envisages that no school or person shall, while admitting a child, collect any capitation fee and subject the child or his or her parents to any screening procedure. Section 15 mandates that a child shall be admitted in a school at the commencement of the academic year or within the prescribed extended period. Sections 16 and 17 provide for prohibition of holding back and expulsion and of physical punishment or mental harassment to a child. Section 18 postulates that after the commencement of the 2009 Act, no school other than the accepted category can be established or can function, obtaining a certificate of recognition from the appropriate authority. The appropriate authority shall be obliged to issue the certificate of recognition within the prescribed period, specifying the conditions therefor. If the school fulfills the norms and standards specified under sections 19 and 25 read with the schedule to the 2009 Act. In the event of contravention of the conditions of recognition, the prescribed authority can withdraw recognition after giving an opportunity of being heard to such school. The order of withdrawal of recognition should provide a direction to transfer the children studying in the derecognized school to be admitted to the specified neighborhood school. Upon withdrawal of recognition, the derecognized school cannot continue to function, failing which is liable to pay fine as per section 19(5). If any person establishes or runs a school without obtaining certificate of recognition or continues to run a school after withdrawal of the recognition shall be liable to pay fine as specified in section 19(5). The norms and standards for establishing or for grant of recognition to a school are specified in section 19 read with the schedule to the 2009 Act. All schools which are established before the commencement of the 2009 Act in terms of section 19(2) are expected to comply with specified norms and standards within 3 years from the date of such commencement. Failure to do so would entail in derecognition of such school. Section 22 postulates that the school management committee constituted under section 21 shall prepare a school development plan in the prescribed manner. Thank you.